Well, hello everyone, and welcome to our conference. I appreciate you all being part of this, and we obviously have some interesting, fun things to discuss. Autism is always at the forefront of any situation in which litigation occurs. It's still a very pressing topic, and we certainly learn a lot from all the cases. And so I highlighted here three cases that I think really provide some information for you and things to consider when you are planning for students with autism. Now, there's one I says a year in review. There's one that goes back to 2022, only because it really does have some important things to discuss. And so technically, we're a little past a year, but it still will provide you the valuable information you need. So the first case that I want to go over, of course, is one that I was personally involved in, and it is one of those things that helps you realize how long the judicial process takes. This obviously was a case involving a student who had autism and a speech impairment. And we'll go over the facts with it, but I want you to know that the parent filed for hearing on July 30th, 2019, initially. Okay, and initially it was for a private school placement for the school to pay for it. Subsequently, they amended their petition as for residential placement. Um, and the hearing got continued several times based upon the parent wanting to continue the hearing. And the hearing didn't occur until sometime thereafter and have 4 days of hearing, almost a full week of it. And what was interesting, the decision was rendered on April 12th of 2021. Now, you have a 60-day time period to appeal, and it was appealed on July 6, 2021. Okay, so we're looking at this time frame. Remember, the initial filing was on 2019. And then the decision of the district court just happened. It was January 26, 2024. So, a little over a month ago is when we got the decision. So you can see how long this process takes. Even the appeal process, it was 2.5 years before we got a decision. And this is for reimbursement for residential placement. And I'll tell you about the implications of that simply because if it had ruled against us and we appealed it, we would have been held responsible for that 2.5 years for residential placement, even if we got it overturned. Fortunately, the hearing officer ruled in our favor, which was a great thing, and also the federal district court ruled in our favor. But you can see this is a long process when you're dealing with an appeal. And the permutations that happened during the due process hearing also made it long because it went from 2019 to 2021. That's a pretty huge gap of time. And so when you look at that being almost 2 years in the due process aspect in the administrative level, and then 2.5 years for an appeal process, we have a long time that we're dealing with it. So let's go over some of the facts of it because it was a very intriguing case, but there's a lot of good information occurred. Want to tell you the decision that was rendered by the federal district court was 78 pages. It's basically an encyclopedia of special education law, but it really brings to fact things that we need to take into consideration and when we would be liable, when we wouldn't be liable. So it's a very thorough decision with a lot of good information for you when you are determining eligibility and also programming for students. So let's go with the back part on this kid. So this child had been in the school district, since they were early childhood, and this child qualified as autistic in speech and eventually OHI for ADHD. And he was plugging along pretty good, but he started showing behaviors. The more he aged, the more behaviors that he had. And he was having meltdowns more regularly. And his physician said that he, in the fourth grade year, and this is when we're moving on, that he could be on homebound when he couldn't tolerate coming to school. So the school district looked at that and incorporated that into their IEP and had him attend for a shortened day and then when he was in able access, he did it. Well, he had a really good year academically in the fourth grade year, and his behaviors had reduced significantly. Although he did have behaviors, she had gotten them to reduce significantly, and she had never restrained the child. And so, because of how well he had done in the fourth grade year, and because of the quality of that teacher, the parents requested that he be held back so that they could have that teacher again. So you can tell when that occurs that they truly do think the program is appropriate, the teacher's hitting the mark for him academically and behaviorally. So he had a second fourth grade year for the fall semester he attended, and he continued to do well with the teacher. He still had that squirrely thing from the physician on homebound saying, hey, if you can't tolerate coming to school, you can do homebound. But he certainly was doing well, and the school was increasing his time at school and felt that he was being successful. Uh, in the spring semester of that year, the parents withdrew him because they were going to go live in England, and so they were gone for that semester. So when they came back in the summer, they still had the physician give a note saying, yes, the student could be on home ground if he couldn't tolerate a longer day. He started on a different, uh, with a different campus, with a different teacher, and a huge return. So, I mean, he'd been in another country and come back. And so he did have some behavioral challenges, but not to the extent that were big issues, but he was being sent home on homebound several times during that time. And so the parents in that semester pulled him and put him in a private program for kids that only had autism. So that's your first red flag that something's amuck. And then they asked for the school to pay for it. And the school had an R meeting in November and said, hey, if he can attend full time over at this private school, then he can attend full time here. We've got a program, we'll develop it, we're great with it. And then the parents said no. Parents later contacted the school and said, I'm gonna file for hearing unless you pay for this private school. And so at the time, the school waited and said, in terms of the cost of litigation and the cost of this private school, we'll go ahead and settle, and agreed to pay for um, the private school for the remainder of that year into the following school year, and didn't say they would pay for that school specifically, but said they would pay for this lump sum for educational services to be provided during that particular school year and the next school year. And that's what they did. Well, when the funds from the school were drying up and they were no longer going to be there, right before that occurred, the parents in the April of the year in which the funds were going to discontinue sent a letter saying, hey, I want you to pay for this private school because this is the situation with it. We think this kid has done remarkably well at this private school, and it's the first time he's ever done well. You all, you as a public school have done nothing for him, and all that fun stuff. So that's where they came to be, and so when that occurred, the school said this, and obviously because they'd already been in litigation, they involved me. And so we recognize this, and this is one of the situations we said we need to have an ARB meeting, we need to do new evaluation, we need to get information of its current services, and we need to visit that school and observe them in that school, because reality has it, there is not a private school that has a student that are only for students with autism that can do as well as we can do. First of all, because we have non-disabled peers. But second of all, we have resources to provide a variety of services that will be appropriate for that child. And so that's what the school did. So even though they were not enrolling him in the school, we said we're going to have an ARB meeting. And in that ARB meeting, we said we wanted to reevaluate the student because he hadn't been in our school for over a 2-year period. Excuse me, it was almost a 2-year period and hadn't been evaluated in a while. And so we wanted to do an evaluation. We also asked to observe and ask for information from that private school. So the parents said, no, we want him to go to the private school. this private program for ABA, and we want you to pay for it for the summer as well. He needs to do the summer program, the equivalent of ESY over this private school. You need to pay for everything. And so our meetings were held before summer. 3 separate ones were held. And one was to obtain consent for the testing. The school didn't get but a one-page document provided by that private entity saying where the student was currently performing. It was very, very basic. And they wanted to do observations. And, they did a couple of observations. And based on all the information they had, they developed a program for the student. Interesting enough, based on the one-page document said where he currently was performing, he was performing less at a lower level than he was performing when he had left the school over 2 years ago, based on the PLAPs that the school had the previous 2 years prior. So this little program was supposed to be so great that the parents said it was so wonderful, and he's done great with academically. The student had definitely showed regression. They had asked for a BIP, they had asked for IEPs, they didn't provide either of that, they didn't have either of that. Asked for behavioral data on the student, they didn't provide any of that information, they didn't have any. But the parents said, no, this is the program, and we want you to pay for it, and the rest. So the school said, no, we've got a program. They did several things. They did social stories that showed the new school, where it's going to be located. They were agreeing to go over and work a couple of days with our school staff, with the private school, to have him become familiar with the new providers that would be at our school. They offered to pay for the providers over at the private school to come for a couple of days to help transition when he actually attended the school. And the parent just didn't bring him. Continue to put him in the private school. Well, ironically, though, for the first 2 weeks, this student and the family vacationed in Europe. So we finally, in those ARD meetings, we also developed a IEP for the following school year, pending the results of the evaluation. Because certainly we hadn't had the student in our school, so we had to rely on other people's information to develop a program. But we had to have a program in place for him to come back. Now, the parents never brought the student back to school. Never. They continued the private school. Now we went ahead and we conducted our evaluation and went forward. Now the parents in the summer, prior to us completing our evaluation, filed for hearing. Remember, we said they filed for hearing in July of 2019. So we were still doing our evaluation at the beginning of the school year. Parents didn't bring him to school, but did bring him to be evaluated. Left several times saying, wait, the kid's not behaviorally, can't do it. But we did get information. And we did it file. And during that same time period, after the school year began, the parents said they're having too many meltdowns at private school. Now they need it residential. So they amended their request to include residential placement. And so after the school district completed its evaluation, they held an ARD meeting to review the evaluation. In addition to being eligible as a student with autism and speech and OHI, the school also found that he met the eligibility criteria for an intellectual disability. The IEP also at that ARD meeting was revised based upon the evaluation. There wasn't great changes, but there were some changes. And so the school had the IEP. The dad adamantly disagreed. In every ARD meeting, he said, I don't want to talk about the program. I just want to talk about placement. It was explained to him, hey, we have to go over the program before we can determine what placement a student needs. The dad vehemently disagreed with adding the ID label, and he continued to request residential placement. And so the school said, since you're disagreeing, do you want to have another ARD? He says, I'll wait until you get information from the residential facility, because by the time we had that ARD meeting, when the evaluation was completed, the student within a week's time period had gone residentially. So our staff, actually, it was out of state that the student was placed. And the director and the behavior specialist went to go visit that school. and they had asked to observe for 2 days. They let them observe for 1 hour, and it was for a non-academic thing. But they did talk to the staff, and the staff said, well, our focus isn't academics, it's more medical in nature. And even though they did have a company, it was called the Einstein Academy, to provide educational services, that wasn't their focus. And it was basically the kid was receiving, if he attended the full time, 10 hours. And the staff also conceded that the student had regressed academically. We also subpoenaed the records and found that the student, of the 10 hours they was supposed to get of instruction, he didn't attend a lot of the school. And they not only did that, they would isolate the child. Things that they would do at the residential facility was put a kid in the room by himself repeatedly without any staff there, without anybody even supervising. He'd be left in a room. They'd also would do restraints, physical restraints, but they'd also do medical restraints. They would give Haldol when a student thought the student was being aggressive. Also, the records show this kid was being attacked by other students. He received some injuries because other students had physically gone after him. And so when they came back, the school came back with the information, had an R meeting, and determined that, hey, we can provide an appropriate program. And that's the student had actually, well, the student had regressed when he had been at this private school from when they had been at our school 2 years previously. The student had significantly regressed even from when he went from the private school to the residential facility. The student was not at any academic level that he was before. And so those were things that were taken into place. Now, based upon their visit, they thought for the transition back, and remember the staff had said, well, I'm sure that you could provide appropriate educational program. And so the school made some revisions, adding 3 staff members to this one student for the initial 2 weeks of the student coming to school to help them transition in, and then reducing that down. They also provided the student could be out for general ed. Now that could change if once the student gets here and it's not something that works, that they could change that where he wasn't in general ed for any length of time. And of course, the parent again disagreed, didn't want to talk about what program and programmatic issues we had, and said pay for the residential placement. Ironically, too, between the time where the dad was vehemently against the ID label being added and this ARD meeting, the parent had actually gone to an outside agency to get the ID label added, and the evaluation found scores for the full scale IQ was within 1 point of ours. So this big argument about we clearly did not know what we were doing. The student was really autistic and was an ID. They gave that one up because they already went and got an evaluation and actually personally sought to get the ID label. When they were fighting the school district about that label, they said, no, he's autistic. And then school said, it doesn't matter what his label is, but we want to put this label on because it could impact what services he may be able to receive outside of the school. So we're going to program based on what he needs, but these labels may have relevance for you for outside services. So then it continued to drag on. They're asking for continuances until the next school year began. And when the next school year began, the annual ARD was due. And they tried scheduling ARD several times in advance with the parent. And the parent says, I don't think we need to go to ARD until after the due process hearing has been held. And it was explained to the parent that this is mandatory timelines. We do need to have an IEP in place for the current school year. It's an annual ARD. We want to have the ARD. And the dad said, no, I don't want to, you should be able to hold out until after the due process hearing. And the school informed them they would go forward with the ARD hearing. The parents chose not to attend. So we go through this. There's, as we said, a week-long hearing, lots of testimony, lots of things going on. And remember, part of the time when he began some of the residential services, we were also now looking at not the whole time that he was there, but the second semester, remember COVID was happening um, in the spring of 2020. Remember, March was our big abyss into the COVID world and remote learning and all the rest. Well, that's where he was residentially. And then when he was coming out, they did recommend, and it was right before our hearing occurred, during Thanksgiving, they said he could be reduced to a lower level residential facility. And so the parents picked him up, excuse me, one parent, the father, not the mother. The mother was not involved at many of the art meetings. She attended one. And the father picked the student up, and he was the one who attended many of the family meetings over the residential facility, picked him up, and before Thanksgiving, dropped him off at the other facilities. So the student spent the Thanksgiving basically in quarantine. He was by himself with just discussion with two staff members who could be with him. He wasn't in the educational program at all. And so they placed him in a place in Houston, a residential um, a school for him then. And so he spent Thanksgiving in this facility rather than his family. And then they try to argue, well, look, he needs this in order for him to continue. And from that point forward, he was at that particular facility, at least to the time of the appeal. So now the court ruled in favor of the school district and said we had an appropriate educational program for the student. It also said our evaluation was appropriate. Obviously we assessed in all areas and the student had behavioral issues, but we were still able to glean from that formal assessment as well as information from others regarding what his educational program should be, which could be adjusted once he came and we saw he may need something different. The court also found that it was a medical rather than an educational placement that drove that residential decision. And it found that the facility's focus was not on educating the student and that it provided a highly restrictive environment that utilized seclusion and other forms of restraint, including medical restraint. It also found that the residential facility was a hospital facility that was not for educational purposes, and that while it had an educational component, it was clearly not the reason for the student's admission. So it found across the board for us. Now, the reality is, by finding we had an appropriate program available for the student, the court didn't even have to go into whether or not the private school was appropriate, but it did find both. It addressed both those issues. And so the school district's decision prevailed. Now, what can we glean? Remember, it was a 78-page decision. So what did we glean from this? What lessons were learned regarding this case? And there were quite a few. And some of them you obviously know, but I want to go over them because I think it's important. Okay, so one thing a court said, to determine whether an IEP provides a meaningful educational benefit, courts must look beyond mere weaknesses caused by the student's disability. They must instead focus on students' overall educational benefit, not solely disability remediation. So when we were looking at it, it's just basically when we're looking at whether or not a student is making progress, which is what we're required to do, is provide a program that gives them the floor of opportunity to receive a meaningful educational benefit, then we looked in the totality, where are these educational benefits coming? And we do not compare the student with his peers, but against himself as to, is he making gains? So progress on IP goals and objectives, as well as recorded test scores and percentile ranks, can aid in the process, but no one factor can overwhelm it. So meaning, sometimes we can show the students made progress by looking at standardized scores, comparing the standardized scores if the student fully participated in the standardized testing. If their scores remain the same, then they're at least making growth equal to their peers to stay at that level. Now, in terms of that, sometimes standardized testing doesn't work, like a student doesn't fully participate in the rest, so that's why we use different criteria. Or with respect to a student, when we do standardized testing, sometimes, as we know, the standardized tests have limitations in accordance with the protocols in their instruction manual that you have time limitations. You can't prop, can't do things. And so while a student who has slow processing or something that might like that, they may know the material, but it takes them longer to do. It's not showing the full level of the student's abilities. So sometimes the standardized tests tend to focus more on weaknesses than giving a full picture. And so certainly I recommend whenever you have that happen, you use dynamic testing and use a variety of sources to determine what this child's programmatic um, issues should be, or what things we should do for them programmatically. Now, obviously, we have to follow guidelines for determining eligibility, but for programming, we can use a full source, and so can we use the sources when we're determining eligibility. So next thing, determine LRE. We have to determine whether the regular classroom with the use of supplementary aids and services can be achieved satisfactorily for the child. If it cannot, and we tend to put them in a more special education setting, we have to ask whether the student has been mainstreamed to the maximum extent appropriate. In this instance, obviously, they said we clearly were a less restrictive environment than a private school or a residential facility. Why? Because it's their home school. So you're already ahead of any private school or any residential facility because it's the home campus. And the access to non-disabled peers is a huge component, and particularly for students, for all students with disabilities, but students with autism, we think them being around typically developing peers for good social skills is important. And so doesn't mean that we don't have them in self-contained settings to address academics, but we do want them to have the opportunity to at least be around students without disabilities for the purposes of modeling. The other thing that's important to remember is that the statute leaves the primary responsibility for formulating the educational program and for choosing the educational method most suitable to the child's needs to the state and local education agencies in cooperation with the parent and guardian of the child. What does that mean? That means that we are still considered the experts. And while we try to accommodate parents' opinions, and many times I can't tell you how many hours that I've been in where the parent says, I am the expert on my child because I am the parent. And certainly the parents have a lot of input regarding how the child's performing, but educationally, the experts are you. And so you need to make sure that you do what you think is appropriate for this child educationally. And while we can try to accommodate the parent, our ultimate responsibility to do is what we think is right. To do anything less is going to make you vulnerable for a lawsuit, because even if later on, you said, but hey, the parent wanted that and it didn't work out, they'll say, hey, you are responsible to do what you think is right by the child, not to appease a parent. Now, the parent doesn't have veto power. Cases repeatedly say that the parent does not have veto power, so you must do what you think is appropriate for the child. It also indicated, and it's something that we know, is that we determine educational methodology, not the art committee. We're not doing that. We determine what the appropriate goals and objectives are. We determine what the PLAPs are, accommodations, scheduled services, related services, the rest, but we're not saying what methodologies you're going to use. They may change. And so you want to not put a specific methodology in there. We talk about what strategies we may use, but we're not going to put, we are going to use this for reading. You may not think it works. Then you have to go back and change it, amend it. We don't want to do that. So keep that language out. We just have to make sure whatever methodology we use is appropriate for that child. And so keep that in mind when we're developing the program. We have to decide, good PLAPs, and I do want to emphasize this, make sure your PLAPs have good baseline data and begin with strengths and then the areas the student may need support in. But you want to have solid baseline. I like to use the PLAPs, and I think it's very helpful for when you get in litigation, but it's helpful if a student moves to another district, or it's helpful for us when they go to another campus. Our different teacher is saying where the student started and where they are at the annual art. To me, your PLAPs are the teacher's report cards. So make sure that you, in fact, have solid PLAPs showing, hey, we've made great gains. It should make us look good because they are ours. And remember, if a student, the more involved a student is, you break down the goals and objectives more and put what level of prompting so we can see that the student has made steady gains against themselves. Now, if we properly offer a FAPE to the student, if we do it timely and we're providing FAPE, then there is no obligation to reimburse for private school expenses. What I want to emphasize here is that just because the parent didn't enroll, and I've had schools say, well, they didn't enroll them, so we don't have an ARD. It's like, oh, no. When a parent's asking for private school, you have an ARD to say, here is what my program will be. If they don't have a current evaluation, you do a current evaluation. Because remember, even if they're in a private school, we're obligated to do evaluations. Get all your data together to develop an IEP, and the parent rejects it, they can. Then send a ready, willing, and able letter. But you need to have an IEP in place. If there's no IEP in place, they're going to rule in favor of the private school because you didn't offer a FAPE because there was no program in place. So even if a kid doesn't enroll, the parent's saying, hey, I want private school expensive, say, we'll have an ARD, we'll get our evaluation, we'll develop the program. This is what saved the school district. Remember, the parent had no intention to ever bring that child back to the school. Never. Those parents didn't want it. All they wanted to discuss was private school being paid for by the school and residential being paid for by the school. They didn't enroll the student, but the school went ahead and developed the program. The school went ahead and did an evaluation so they could have something in place. And if the parent chose not to access it, then no one can say that we didn't have the offer of FAPE because it was there and provided. So I want to emphasize that, strenuously, because just because a student didn't enroll, if there's a student in your district and you know they have a disability, you better have an ARD and then at least ask to get the evaluation. They can refuse it or try to develop a program, get information of where they are, and they can reject it, but we have it in place. The other thing is IDA authorizes reimbursement of the cost of a private special education services when we fail to provide FAPE. So that's why I'm saying make sure you have an IP in place. But they also, if let's say we fail to provide FAPE, they still have to find the private school placement is appropriate, regardless of whether the student was receiving special education related services through public schools. So the point being is, let's say we say, oh, the kid doesn't qualify for services. And there's a case, Forest Grove, that's out there that said, we said the kid didn't qualify. Parent got outside evaluation, said they fined him, put him in a private school, and then sued the school district for the private school. And they said, hey, just because you didn't identify them as special doesn't mean that they can't bring a lawsuit. Because the reality is you may have failed to meet your obligations for child fine or determine eligibility. So therefore, they have the right to bring a suit. Now, even if they determine the school doesn't provide FAPE, hadn't provided FAPE, and that the private placement was appropriate, the courts can still reduce the amount of reimbursement if they think equities warrant, meaning if the parent isn't cooperative, the parent doesn't do things they need to do. Now, of course, the review is limited to whether the IEP is reasonable. We don't have to provide the best or the most perfect or most ideal IEP. We just have to provide one that's reasonably calculated to enable the student to make progress in light of his or her unique circumstances. Now, the 4 factors that you will look at whenever you have a residential placement case is whether the program is individualized based on the student's assessment and performance, whether the program is administered in the least restrictive environment, whether the services are provided in a coordinated, collaborative manner by the key stakeholders, and whether positive academic and non-academic benefits are demonstrated. And the court recognized in this case, they said, hey, the kid hasn't come to school, so it's really hard to tell them whether or not they would receive academic and non-academic benefits. But, until the child comes there, we wouldn't have to do it. It also brought up with IEP, an IEP can be sufficient under IDA, even if it's not perfect, and even if it doesn't insulate the child from experiencing hardships while being subject to IEP. Meaning, if the student, still has behavioral issues and things occurring while they are under this IEP, it doesn't mean the IEP is wrong. It just means that the student may have other things going on. Now, and it also emphasizes again that just because the parent's position regarding the child's education is not adopted by the committee, it does not mean they weren't permitted or given the opportunity to participate in their child's education. We can listen to the parent. We don't have to agree with the parent. We have to agree with what we think is appropriate for the child. Now, it also included that freedom from restraint as a benchmark of LRE, along with the freedom to associate with non-disabled peers to maximum extent appropriate. They also brought up the fact that the student's behavioral issues affected his ability to receive educational benefit did not transform the issue from a medical safety issue to one primary for educational purposes. If a student needs hospitalization for medical or safety issues, that transcends any educational issue a child might have. And that IDA is not intended to provide hospital admissions or pay for them if the parent unilaterally chooses that route. So for a residential placement to be appropriate in IDA, it must be essential for the student to receive a meaningful educational benefit, meaning the primary purpose of that residential placement is due to their disability. As we've already said, we don't have to do a thing, and we don't have to address the desire of the parent or every medical need. And just because the student is hospitalized doesn't mean they haven't provided FAPE. There are outside factors that happen all the time to a student being hospitalized that have nothing to do with us. The other thing that happened in the hearing is that the school's experts came forward, and everybody did, said, we put this IEP in place, but we can certainly change it once the student comes here and we see that there may be some modifications to it. And what the court found was that flexibility does not mean that the IEP that is developed is insufficient in a way. It just simply means that things change. And so an IEP can be changed based upon the needs of that student. So we definitely want to look at it from that aspect. Remember also, these are important things to bring forward on this. Procedure errors do not constitute a violation of the right to FAPE, showing that it's caused substantial harm. And this is the one I want you all to think about too here. Without a reasonable request to delay or reschedule, there is no substantive harm from a school proceeding with a needed ARD meeting that parents have declined to attend. Absent a showing that request for delay was reasonable, a school district's failure to accommodate a request to delay or reschedule does not seriously infringe on a parent's opportunity to participate in the IEP formulation. You get this all the time when parents have advocates or they have attorneys, and particularly when they have filed for due process hearing, they're like, we're not going to go back to ARD. We're not going to do it. Well, this clearly shows that we still can go to ARD. We can try to get the parent there, but if the parent doesn't show and we've made reasonable efforts to include them, you can go forward with the ARD. Make sure your deliberations show the efforts that you've made to try to get the parent to participate. And if they don't participate, you've made them aware that you're going to go forward with it. Okay. And another one they challenged is, hey, you didn't have since he hadn't been in school for a couple of years, you were required to have the teacher from the residential facility there. And the court said no. It said a soon-to-be teacher satisfies the IDA requirements for the members for a student who is not currently attending school. Think about it. We have kids who transfer in all the time from other schools and rest. We don't have the other schools teachers be there. We have our ARD with our soon-to-be teacher. All right, that was a lot out of that one, but that one had the most information that will help you for drafting, and so I wanted to go over this. This is still a really interesting case, and it's involving a student, again, with autism. Now, he entered the school with an IEP for speech in February 2019. Evaluations was conducted, and it was determined the student no longer qualified for special ed, and that his needs in the area of sensory, self-regulation, and attention issues could be effectively addressed in the classroom. The parent agreed to the dismissal. However, the next school year, the teacher indicated the student had some issues with test refusal and sensory difficulties, but he was receiving passing grades. But let's go to the next school year. And at the beginning of that school year, the teacher noted that the student was refusing to do work. And the teacher and the father emailed to discuss strategies to help the student in class. And the father mentioned obtaining a private ADHD evaluation. Well, in November of the year, the teacher initiated their RTI because of the lack of the participation activities. Now, the teacher also testified at the hearing that he was trained to initiate, respond to intervention services before requesting a special education evaluation. Ooh, little problem there. Now, the SST services started in November of 2021. They provided accommodations to students, but the students continue to have a lack of participation and group work refusal. It didn't improve. Even in March of 2022, with accommodations, a student was refusing to complete work 80% of the time. So the parent requested an evaluation of April 22. The school began the evaluate process in May and completed in October of 2022. Now, the evaluation did not include an FBA or an OT or counseling assessment. It did evaluate for autism. Now, the evaluation found the student had deficiencies in social communication that led to substantial interference with everyday social interactions. And those are typically associated with the diagnosis of autism. The evaluation also showed many characteristics of a child on the autism spectrum, but the evaluator concluded the characteristics were due to ADHD. The evaluation found that the student qualified as OHA for ADHD. Now, the ARD meeting was held to place the student in special ed. The parent returned the IEP indicating they agreed that the student qualified for special ed services, but disagreed that the student did not qualify as autistic, nor did they agree with the IEP. The school treated this as a disagreement to place the student in special ed and did not provide special ed services. The parents filed a hearing and obtained a private evaluation from LSSP and a BCBA that found the student qualified as a student with autism and ADHD. Okay, so the hearing officer ruled, he gave some relief to the school, but overall ruled in favor of the parent. And what the hearing officer found is that the district had reason to suspect that the student was in need of special education related services as a result of disability by the beginning of spring of 2022. Now, he found that we also had reason to suspect earlier, but he found for sure it happened to happen in spring of 22. He said the interventions that were beginning in November of 2021 continued from the beginning of the school year to the end of school. In the spring of 22, those interventions were unsuccessful and the student still wasn't participating. In fact, the student was not doing 80% of the work. So clearly the student was not making gains in that area. So they said the district initiated the evaluation only after the parent requested one. And so the hearing officer found that that delay between the time of January and May to initiate the evaluation was unreasonable and violated the child fine obligation. Okay. He further found that the district failed to identify the student as autistic, even though the data contained an evaluation from the hearing officer's perspective conclusively found the student met the eligibility. As such, the hearing officers found the IEP to be inappropriate because it did not have clear goals for social skills, nor did it address the autism supplement. So what do we need to look at? First of all, now a delay in evaluating can be reasonable if the district takes proactive steps between notice and referral. That's what the court talked about, the hearing officer talked about, but it said, while RTI interventions are proactive, when those interventions are working, a district needs to evaluate a student. And the other part that you've got to be aware of is student does not need to, and this should be drilled in everybody's head, that a student does not need to go through interventions through RTI before being referred to special ed evaluation. Remember, we have an obligation to evaluate when we suspect that a student has a disability that is in need of specially designed instruction and special education related services. So we can't make them go through hoops before we evaluate if we suspect something's going on with a student. And clearly there are many red flags that show that we suspected something was going on. Now, the other thing is, let's say this parent came back and didn't agree to everything, but did basically agree to special ed services, which means they agreed to placement in special ed. They didn't agree to the IEP or that student's qualifications. That is a disagreement, but when the parent agreed to special ed services, that should allow that student to get in placed in special ed. The hearing officer didn't go after the school much on that, but I want you to be fully aware when we have qualifiers on her, then go ahead and come back to R to make sure you understand what those qualifiers are. And so that we don't delay providing services to a student because we misunderstood what the parent had checked or said. The other thing, now while a label doesn't drive programming, and I really want to emphasize that again, an eligibility gets you through the gates of special ed, but once, and that's the admission ticket, but once you are in, you can ride all the rides, which means you address the child's full educational needs, which means their strengths and their weaknesses. You're going to design that program. So the issue of whether the child was identified as autistic or not really isn't the biggest issue. The issue is, did we program based on all his needs? And if you choose not to add that label for autism, even though there may be characteristics of autism, I strongly suggest you don't call it the autism supplement, but address all the elements of the autism supplement and to ensure that all those needs are met. The one thing that is very important here is that the autism supplement does not, those aren't services that are just for autism, they're for any child in special ed. It's just because there was very strong lobby that said let's get an autism supplement, that's why we have one. But those services are there for any child who needs them. So it would behoove you to just make sure you've addressed extended school programming, and you've addressed staff to student ratio, you addressed communication, you addressed in-home training, parent training, you've addressed all those things to determine whether or not those are actually needed. And then you'll be okay. Whether we add the label or not, if we are addressing needs, we're okay. Now, when conducting an evaluation for autism, I really do think an OT should be part of that multidisciplinary team because we have the strongest evaluations within schools. And we have a strong team, which includes speech, because obviously it has communication as its base. We have normally an LSSP, we have the teacher input, OT, who also, the staff will also address AT needs. I want that multidisciplinary team to be comprehensive enough so we can address any area. Because there are issues, again, of sensory needs, and it doesn't mean that they necessarily have them, but we want to rule it out. We also want to look, if we're looking at autism, one of the things we look at is behavioral interventions for students we shall look at behavioral strategies, just do an FBA. Now, the other thing with this, when they came up with their IEP, they were offering basically the same types of services that had proved to be unsuccessful. We've got to do something different. If what we were previously doing in gen ed isn't working, then we've got to make sure we do something that is different. All right. And again, it's another good case, and it deals with eligibility and those things, which I think are very important for us to look at. And in this particular one, we had a student had 2 outside evaluations that diagnosed him with autism. The parent had requested a special ed evaluation beginning of the 2019-20 school year. While the evaluation was pending, the student received Section 504 services. Upon information provided from observation, using the information from observations, interaction with student, parent and teacher information, testing data, the LSSP, the educational diagnostician speech, there's completed the child autism rating scale, which was a behavior rating scale determining whether a high functioning individual had sufficient symptoms to be considered for a diagnosis of autism spectrum disorder. Now, the student received a raw score below the standard clinical cutoff. However, the CARS was complete before the occupational therapist completed evaluation, which showed numerous areas of sensory processing dysfunction. Now, the 2019 IFI did not include further assessments specific to autism. The LSP relied on the student's previous diagnoses, ability to interact socially with students and make eye contact, and lack of sensory seeking indicators and not conducting the ADOS and other measures. Now, the BASC was also administered, and the teachers gave ratings on the Autism Probability Index in the clinically significant range, with the parents' ratings at the at-risk range. Across students, the student demonstrated impaired emotional social reciprocation and rigidly adhered to routines and rituals. Now, on the Emotional Behavioral Disturbance Probability Index, they also were found within clinically significant range. So what the school did find is that the student was not eligible as autistic, but as emotionally disturbed. Now, because the student had been eligible for services since 2018, the hearing officer found the district satisfied its child fine obligation. So child fine means, are you providing the child special ed? Clearly, this child was receiving special ed. And they also did another evaluation in 2021, again, not finding this child autistic. So what the hearing officer said, really, this is a challenge to the failure to appropriately evaluate and identify the student, and also whether or not, because of the failure to identify, did we provide the student FAPE. So the hearing officer found that the FIA was not sufficiently comprehensive in the area of autism, and its conclusion the student did not meet the eligibility criteria for it, and despite the two previous ones, and that it used a single measure. It also found that the rule said he didn't qualify, even though he had significant social deficits. It was due to cognitive distortions, but not assessed for cognitive distortions. And so this conclusion was reached without data to support it. And there was an outside evaluation that was done that thoroughly explained that, yes, the child did meet autism rather than emotional disturbance. In determining the student did not meet criteria of a student with autism in September 2021, the hearing also found the district inappropriately discounted the ADOS administered by the outside evaluator due to concern over scoring validity related to the use of plexiglass shield during testing. However, the outside evaluator during her testimony said that she did not conduct the evaluation with the plexiglass shield between herself and the student. It also found that the district misinterpreted the ASRS findings of the IEE. The hearing officer found because autism was not identified, the student did not receive behavioral supports that would be unique to autism, and that the services contained in the autism supplement were not addressed, so therefore the student did not receive FAPE for those things. So what do you learn from this case? We know that if a child qualifies, then we've made our child fine obligation. However, when we're dealing with identification, then the issue is FAPE. So the label doesn't drive the program. So whether they're autistic or AD is not really the issue. The issue is whether they receive FAPE. That's a concern. Where they went after the school was they said they only used one sole criterion for determining autism, the CARS, and in essence, you could tell that this hearing officer truly believed that ADOS was the gold standard. They should have didn't say they shouldn't have used it, but they just said they shouldn't have used this one sole criterion, and that their own evaluation clearly showed that the child had autism, and they contradicted that and didn't find that. And also, it shows that we have to consider academic, behavioral, and social progress to determine whether special education services are needed for the eligibility. The eligibility is a two-pronged test. Do they have a disability, and by reason thereof need special ed services? And also, in making an eligibility determination, you have to draw from a variety of sources, and that's why standardized testing is a small portion of it. And I also look at it this way: the more informants you have on an autism evaluation, the better for you. Because the reality is, even the ADOS or any of these tests, it is subjective. Where it's not where we can say this is truly an objective determination, because ADOS is based on what whoever's administering it perceives them to be doing. I've had some evaluators that determine anytime they gave ADOS said the kid was autistic. I had some who every time they gave the ADOS said the kid wasn't autistic. Relying on one informant, or one person making a decision, it makes it very hard to sustain. I think having the multidisciplinary team looking at it from a variety of different aspects always strengthens our ability to defend our evaluation. The other thing that I think is very important to recognize in this one is that if a student meets the characteristics, or they're in some instruments, they meet the cutoff and some instruments they don't meet the cutoff, we have to be able to explain why we're choosing not to make them qualify under that particular eligibility. And in doing so, we've got, if we're saying it's due to something else, like they said, the cognitive aspect, then we have distortion, then we have to assess for that area to say that this is in fact the reason it's happening versus reason it's not happening. One thing to do, and if you are on the fence of whether or not a child qualifies, then do additional testing so that you can rule it out. The more information you have, the better chance you have at truly identifying what the student has going on so that you can program for it effectively. Again, your focus is on making sure you know what all the strengths and weaknesses are, and that the IEP reflects that you have addressed all those needs. This one also goes back to, they were going autism supplement. Remember, you didn't find the kid is autistic. If it's on the fence, go through all those 11 areas to just see if the student needs. And remember, they're open to any disability. They can be open to a student who is ED. This is what they found this kid to be, ED. You can still look at it from that aspect. We want to make sure we have that there. You also want to, when you're doing an FBA, as we said, we want to do an FBA, we're looking at autism. Make sure we look at those 4 functions as whether or not, what is motivating that student's behavior, and collect sufficient data so that we are be able to appropriately defend what we're doing. So that's a lot of information provided in a short amount of time. We could probably go on forever regarding this topic. The important thing to remember is always work with the parent, but follow through with what you need to get done. Do evaluations. If you don't have a clear determination of evaluation, then do additional testing, gather more information, know what else is going on. Try to work collaboratively with the parent, but remember, you ultimately have the child's best interest as your focus and must develop a program based on the child's needs. And when we have parents who are being very difficult and coming to an ARD meeting, then send them a letter. Say, we have scheduled with ARD. If you can't make it, give me an alternative dates by this date. If we don't get the alternative dates, it will go forward on this date. Because that way you're making an effort to make sure the parent, it's a mutually agreeable time, but you also let the parent know, we've got to get these services in place for a student. When you delay and don't provide the services, then you're very vulnerable for a compensatory education claim, and we don't want to do that. So I am now going to take any questions. For those of you who have already stayed longer than you wanted to, you can certainly leave. But if not, then we're gonna go with the questions to see. It looks like we got a few. Okay, let's go over here. No, it looks like we don't. Okay, the question is, how do we make sure that we deal with parents not coming to the ARDs? Again, do you have to do it 2 times, 3 times? My view is you do it, I don't care if it's 2 or 3 times, but you need to make an effort. After the first one, most of us just send out an ARD date because we have dates we hold ARDs at schools. If that doesn't work for the parent, then, and they say it doesn't work for the parent, then send them a letter saying, this is, if this date doesn't work for you, give me alternative dates. Here's another date. If this doesn't work for you, give me alternative dates. If I don't, and please give them to me by this date. If we don't hear from you by that date, then the ARD will go forward on this date. So we're making the parent have to respond. If they don't respond, then we've made the parent aware that we will go forward. I think that's very important for you. Let me see if there are any more. It does not appear so at this time, probably because your brains are all bleeding. Hope you got some information from this, that it's helpful, and we will look forward to seeing you this afternoon.